Thank you so much, Isha, Smita ma'am, and whole Taxmann team for providing me this opportunity. A very warm good evening to everyone, all the participants who are present here. Few of the names I can see of my known is Ramashankar ji, Anmol Nakraji, Shamrish ji, and all the participants. So today I am thankful to Taxman that they have given me the opportunity to address the people for a very different and apt topic, that is strike-off provisions and the revival of strike-off companies. Why we have chosen this topic, I would like to elaborate it first. I am not sharing my PPT right now. I would like to elaborate why we have chosen this topic. Is because recently what I have observed is that many ROCs, almost all ROCs have issued STK1 notices to many of the companies who have not done the filing for, you can say, more than 2 years. So all those companies are going to be striked out soon, and there is ample of work going to come into market with respect to the revival of those companies. If that companies actually in working, but they were not having the professional guidance, or due to any express reason they were not able to file the annual returns. So with that intent, I'm taking forward this session because this topic is somewhat I can say not much explored, and that's why there are a lot of practical you can say glitches which is being followed by the professionals while appearing before the honorable tribunal, and whatever the procedure they are following, they are not I can say correct procedure being followed thoroughly. So I will be letting you know the difference between the appli and the application which is mentioned under section 252. Some of the participants were asking in the chat box while Ms. Isha was introducing the topic and me, that whether we are going to cover the LLP strike of provisions also. The answer is no. We are totally restricted to complete strike of provisions today. And I will be letting you know the answers of your queries at the end of the presentation. I would request you to please post your queries in the chat box. I believe in total interaction because knowledge shared in knowledge squared. So I would request you all to be participative and please ask your questions and answers. Questions and answer to my questions, so whichever is I have mentioned in my presentation. So I made certain poses. I will be asking you to answer it. I would request you to kindly answer it in the chat box. Is my screen visible, Isha?
Yes.
Okay. So I've already told you why I have chosen this topic because many ROCs have issued STK1 notices recently, and many of the companies have been striked off. So we will be dealing because for revival of any company, suppose you are going before NCLT for revival of any company, you must be aware of the provisions of the strike off also, because anyhow you are going to challenge the grounds on which the ROC has striked off the company. That's why these two topics go hand in hand. So you have to understand the provisions of strike off, and then I will be coming to revival of strike off topic. So just one disclaimer that whatever view I will be presenting in my presentation is strictly personal, and your view may differ from my view. So I would request you to please share your view with me so that it can be a value addition for me as well. So with this thought process, I will like to go further. So what I will be covering in my presentation is, firstly, I will let you know the meaning of the strike off in simple sense. And then after I will let you know the kinds of strike off. There are two kinds of strike off. One is the ROC initiated strike off, and the second one is the company initiated strike off. Then after I will let you know the grounds for strike off. It's something like that on which grounds the ROC can strike off the company, or on which ground the company can move an application for the strike off. Then after I will let you know the procedure being followed by the ROC to strike off the company, because it is not like that ROC is going to strike off the company at its own whims and fancies. There is a particular procedure which has to be followed by ROC prior to striking of the name of the company from the Registrar of Companies. Then after I will let you know the circumstances in which the ROC cannot take action. Suppose ROC wants to strike off the company, company has not done the filing of 2 years, then also there are certain circumstances in which the ROC cannot even take that action. I will let you know that also. Then after I will let you know the prerequisites for moving the voluntary strike off application by the company. What are the prerequisites and what are the attachments you have to make to STK2 form. Then after I will touch section 248, that will be we will be covering a whole section word by word and line by line and para by para. Then after I will let you know the circumstances in which the STK2 means that the voluntary application for strike off cannot be moved by the company. Then after I will let you know the effect of the strike off. Also, we have observed in the recent past that when the company many of the list has been issued by the ROC for the strike off of the companies,
Simultaneously, the list for the disqualified directors has also been issued by the NCA. So what is the legal sanctity of that list of disqualification of directors? I will touch upon that, but in brief. I am not going to discuss it in detail. Then after, I will let you know the consequences of the fraudulent application. Suppose you move an application for strike off, and that is with some wrong information. Then what is the consequences of that fraudulent application? Then after, I will touch section 252 as mentioned by Isha in the starting, that 252 subsection 1 is having the different relevance and 252 subsection 3 is having the different relevance. I will let you know the difference between those. Then after, I will let you know the grounds for revival. What are the grounds for revival? And also, I will let you understand the just ground. That is the ground where the company is actually not into business, but is having the reasonableness that this company should be restored and the name of the company should be restored to the register of members. I will let you know that also. Then after, I will let you know the prerequisites to move an appeal. Suppose you want to move an appeal under section 252 or application under 252. What are the prerequisites you have to keep in mind? Then after, I will let you know, suppose your NCLT order does not come in your favor and you want to appeal it before NCLT. So what is the recourse available and what is the timeline of that? Then after, I will let you know the effect of this strike of notification on your company. Suppose your company is into you are in employment into some company, and you have been given the responsibility to make the financials in concerns to Schedule 3. So what is the effect of that? I will let you know. Then after, at the end, I will be discussing certain case laws. I am pretty much sure that whenever I will be discussing this case laws, this will be answering most of your questions, whether the company is not having the annual return, but whether that company can just revive. If suppose the company is having the asset, not filing the annual return, not having business, whether that company can be revived. So I have collated certain case laws which will be definitely fitting to your case as well. So I would request you to kindly take that into consideration. So in simple sense, what is strike off? Strike off, I would say it means the removal of the name of the company from the register of companies on certain grounds. It cannot be on any ground. So for the removal of the name of the company from the register of company, there are certain other recourses available, like winding of the company, like voluntary liquidation under IBC, like merger of the company, a merger of one company with another company, in which the transfer company gets dissolved completely. So there are certain ways which allows the company to have their name removed from the register of companies. So strike off means the removal of the name of the company on certain grounds. Even if the ROC is going to strike off the name of the company, or the ROC, or you are moving an application to ROC for the removal of the name, that can be done on certain specified grounds only. It cannot be, in addition, you cannot make any other ground for moving the application under section 248. So that is the simple sense of strike off. If you will start with 248 subsection 1, then it starts with the phrase where the registrar has reasonable cause to believe that. So if you see, it is bringing a test of reasonability on the part of the registrar before issuing the notice for strike off. It means, suppose the ROC is going to issue STK1 notice to your company, it has to first believe, it should have certain reasonable cause that your company is actually not working, or your company is not into business, and your company's name is justifiable to be removed from the name of the register of the company. So this reasonability test is the first, I would say, the first step which has to be followed by the ROC. Presently, what ground they are taking for issuing the notice in STK1 is that the company has not done the annual filing for the last 2 financial years. So that is the reasonable cause to believe on their part that the company is not actually working. But I won't say that it is the concrete belief which will be fitting to all the case. Suppose I would say, let's for example, suppose your company is a Reliance Industries Limited, and that company is actually working into market, but due to any XYZ professional not having a professional guidance, or due to any XYZ reason, that company was not filing the annual return or annual filing, and ROC cannot believe that this company is not working, because looking at the market study, this company is actually working in various ways. So ROC has to do the reasonability test very concretely before issuing STK1. Presently, what they are doing is that they are issuing STK1 on the basis of that the company is not doing the annual filing for last 2 financial years. That's why you might have observed that a lot of appeals are getting filed before Honorable NCLT against the order of ROC of strike off. So that's why 252 cases are an ample before the Honorable NCLT. So this is the first step that reasonability test has to be done by the registrar. That is the intent of 248 subsection 1, first phase. So if we'll go through further in 248, there are two types of strike off. First one is the registrar initiated strike off. Second one is the strike off being initiated by the company itself. That is the voluntary strike off. Now I will let you know the grounds. So there are 4 grounds on which the strike off can be done by the ROC, or you can move the application for strike off. First one is that the company has failed to do the business for 1 year from the date of incorporation. So the usage of words within 1 year of 1 year of its incorporation means whether you can move the application. Suppose your company has been incorporated today, and after 2 months you get to know that you are not having any willingness to run this company further, and you want to strike off the name of the company. Whether you have to wait for 1 year, or you can go for the strike off application after 2 months also. So here the answer is, in my opinion, that you can definitely go for strike off after 2 months. There is no foundation on you that you have to wait for 1 year. You can definitely go for strike off after 2 months also. But practically, what I have observed that many of the professionals are having the view that they have to wait for 1 year. So I am not of that view. You can go for strike off after 2 months also, because that is the contractual thing which you people are carrying by incorporating a company, and nobody can bound you to run that company for 1 year if you are not willing to do so. So definitely, that company can move an application STK2 for a strike off even before 1 year also. Also, suppose that was not the intent. Suppose the intent of the legislature was to make you wait for 1 year. The simultaneous provision of the subscription money not paid within 180 days and INC 20A not being filed, it should not be there, because it is in a way saying that you can move for strike off after 180 days also. That is also less than 1 year. So that's why I am having that view that yes, company can move an strike off application before 1 year also. Suppose the company is not doing the business or has not commenced the business within 1 year of its incorporation. Second is that suppose company is not carrying on any business or operation for a period of 2 immediately preceding financial years. So suppose your company has been incorporated in the year 2015, and till 2017 your company was into business, but after that your company was not doing or not carrying on any business. So that company, today you want to move the application in STK2, that is clearly allowed, and you have to prove that you are not into business from last 2 financial years. That means that you are not doing any bank transaction or not doing any business transaction with any of the vendor. So suppose sometimes the question comes up that whether the company which is not carrying out business but is regularly doing the annual general meeting, and it is regularly transacting the ordinary business mentioned under the Companies Act, whether that business is also covered into this particular word business or operation. In my view, that is not. This is clearly in relation to the business transaction, that is a market work which you are going to do for your company. That is not going to cover ordinary business or special business under the Companies Act. That is not the concept. So fourth one is that the company is not maintaining the registered office, and on the verification of it, the ROC comes to know that there is no one who is representing the company, or the company's registered office is not a proper office. So in that case also, the ROC can initiate, or you can move the application voluntarily for this strike off under STK2. So these are the grounds. So question comes up, the issue was coming while filing STK2 when the company was incorporated, but the company has not paid the subscription money and one INC 20A has not been filed. So the issue was coming that prior to filing of the STK2, the pop-up was coming that INC 20A is required to be filed. Now, some professionals were giving the guidance to their clients that you have to submit the subscription money into the bank account, then after you have to submit INC 20A with the ROC, and then after once the commencement of business form will be approved, you can go for STK2. So in my view, that advice is not tenable. You can definitely, suppose this technical glitch is coming in INC 20A, instead of attaching the bank statement showing the depositing of subscription money by the subscriber, I would say that you should attach the clarification letter that I am filing this INC 20A form due to technical glitch which is coming in STK2. Presently, in my view, that technical glitch has also been removed by the MCA. But suppose in case that technical glitch is still coming in your STK2 filing, then you can definitely attach a clarification letter and you can say that this is just due to technical glitch that we are filing this INC 20A. This does not mean in any way mean that we are willing to commence the business into this company, and we are not hereby saying that the subscription money has been paid by us. So it is just a technical glitch which is asking us to file this INC 20A form, and this is just for your record purpose and should not be taken as commencement of business declaration. So in that case, INC 20A issue will be resolved while filing STK2, and you can directly move for STK2, and you have to attach challan of INC 20A into it. You can definitely add it also. So that will be the solution for STK2 if INC 20A glitch is coming. Now, suppose ROC wants to strike off the name of the company. So there is a particular procedure prescribed under the law that pursuant to section 248, ROC has to issue STK1 firstly. Then that STK1 is the intention to remove the name of the company, which is given to the director and the company by the ROC. So ROC issues STK1 only to two persons, that is the directors and the company. And directors and company gets the chance to file the reply to STK1 within 30 days from the date of that notice. Suppose within 30 days, a company or director fails to file the reply or the reply is not satisfactory, the ROC will be moving forward and he will be issuing, publishing STK5 in the official gazette, MCA, and the two newspaper, that is one English and vernacular language newspaper, that is for the general public. So the question comes up whether, suppose the director has failed to file the reply to STK1, but STK5, he get to know about the striking of intention by the ROC at the time of publishing of STK5 over the website of MCA. Whether that our director can file the reply to STK5 later. So some professionals are of the view that STK5 is strictly for general public and STK1 was especially for director and company. So director and company are not having the right to file the reply to STK5. In my view, the answer is that the intention of 248 is not to strike off the name of the company. Rather, the intention of 248 subsection 1 is to give you chance. Suppose the company is operative in nature, you may come forward and you can tell the ROC that yes, we are operative in nature, though we have not filed the annual return, and just give us one chance, we will doing all compliances. So that is the intention of 248 subsection 1. So suppose you have not filed the reply to STK1 within 30 days, you may file the reply to STK5 in further 30 days. So suppose you have failed to file the reply to STK5 within 30 days from the date of such publishing, then after that ROC issues STK7, that is in the official gazette, and the name of the company is strike out and the company stands dissolved. That is the clear-cut procedure which is being followed. So I have already discussed this question. Suppose you have failed to file the reply to STK1, whether you can file the reply to STK5, the answer is yes. Do not get confused that if you have not filed the reply to STK1, you are not allowed to file the reply to STK5. You can definitely clearly allowed to file the reply to STK5. Moving forward. So there are certain circumstances in which the ROC cannot strike off the name of the company. Neither you can move the voluntary application for strike off. So the first thing is that the company is a listed company. Suppose your company is a listed company and that company has not done the annual filing for the previous 2 years or 3 years, ROC cannot strike off the name of the company. Neither you are allowed to make the application next to it. Second one is the delisted company. Suppose your company is a delisted company, but that delisting has happened due to non-compliance. If that delisting has been done voluntarily by the company, then after 2 years you realize that this company is not doing the business, you want to move the application, you can definitely go for it. But suppose that delisting has happened due to non-compliance, then strike off is not possible, either from the side of the ROC nor from the side of the company. Third one is the vanishing companies. The definition of vanishing company has been given in the explanation to rule 3. And it says there are certain criteria for it. It says that the vanishing company means a company registered under the Companies Act, first criteria. Second, it should be a listed company. Third, that company has not filed the annual return or annual filing for the last 2 years. Fourth, that company's registered office is not maintained. Fifth, the directors of the company is not traceable. So these are the 5 conditions which has been mentioned in the definition of vanishing company provided under the rule 3. I'm not able to understand why this vanishing company definition has been given under the rule, because the word usage of word that the company means vanishing company means a company registered under this act and which is listed over the stock exchange. So it is automatically covering only listed companies which are not meeting other criteria also. So already listed company has been covered under clause 1. So definitely that company cannot be striked off by the ROC, neither by you. So still, if the definition has been given, you should consider it. Fourth one, that the company, suppose any inspection or investigation has been ordered against any company and uh, that is pending, so that company cannot be striked off by the ROC, neither by you. Suppose any inquiry or scrutiny is pending for the company, then also that company cannot be striked off. Suppose any investigation is completed but court proceeding yet to be filed, that company cannot be striked off. Suppose any prosecution under any law is pending before the court, that company cannot be striked off. Eighth one is little bit interesting, that says that the compounding application is pending before the competent authority. Now the usage of word the competent authority under the law, some of the professionals are of the view that this competent authority should be restricted from the point of view of the Companies Act. But in my view, whenever you are going for the compliance, so you should see to the provision for the conservative approach. And this compounding application means the compounding application in any court. Suppose your application is not pending under the Companies Act, but under criminal CRPC. So then that compounding application, if it is pending, then also that company cannot be striked off. Ninth is, suppose the company has taken the public deposit and it is yet to be paid, due to be paid. So then that company cannot be striked off. Suppose your company is having charges and that is pending satisfaction, that company cannot be striked off. Last one is the Section 8 companies. Suppose your company is a Section 8 company. If you want to strike off that company, you have to first change its nature to the private company by surrendering its license. Then only you can go for a strike off, otherwise not. So suppose your company is a Section 8 company and you are willing to go for a strike off, having the status of Section 8 company, that is clearly not allowed. You have to change its status to normal private limited company by surrendering its license. So now moving forward, 248 subsection 2, that is the voluntary removal of the company's name by itself. So if you read the provision, this is the language of the act itself, 248 subsection 2. It says that without prejudice to the provisions of subsection 1, it means it is not touching the provisions of subsection 1, a company may, after extinguishing all its liability, it is the first, you can say the prerequisite for moving the application is that you have to extinguish all your liability that is subsisting into the company. You have to extinguish all of that. Then after, you have to take by a special resolution or consent of 75% of the members. So you have to call the general meeting, you have to obtain the consent of the members by way of special resolutions, or in case suppose you are not willing to go for the extraordinary general meeting, you can have the consent of 75% of the members in terms of paid capital. I would suggest you to go for consent. Why so? Because suppose you will go for the conducting of the extraordinary general meeting and you pass the special resolution, then one more responsibility comes on your shoulder, is to file the MDT 14 to the ROC. In case of consent, that filing of MDT 14 is not required, so I would suggest you to go for it. Then after, you have to apply, you have to file the application in the prescribed form, that is STK 2, from the register for removal of the name of the company from the register of the companies. Now the grounds can be all or any of the grounds specified in subsection 1. It means the voluntary strike off can also happen only on those 4 grounds only. You cannot add any 5th ground to it. So definitely you have to assure that your company is meeting any of the grounds mentioned in the subsection 1. That was the 4 grounds. That is, that company has not done the commenced the business within 1 year of the incorporation, company has not paid the subscription money, and NCLT has not been filed, or the company has not done the business from the last 2 years, or the company is not maintaining a registered office of the company. Now, suppose your company is regulated by a special act. Suppose your company is an NBFC company and it is regulated by RBI Act, or your company is the insurance company and is regulated by IRDA, then you have to get the approval of that regulatory body as well. So this is the clear-cut interpretation of 248 subsection 2. That is extinguishing of all the liabilities. a special resolution or consent of 75% in terms of paid capital. Any of the ground mentioned should trigger. Fourth one is the approval of the special regulatory bodies, IRBI, IRD, etc. So the clear list has been provided under the rule. So the question comes, suppose that whether an inoperative company can be striked off, where there is no liability in the company, but company holds the asset. Again, coming to 240 subsection 2, it is clearly saying that you have to extinguish all your liabilities. It is not touching upon the assets. It is not asking you to dissolve all your asset or dispose of your all assets. It is not asking that. So, but generally when we move the application STK 2, we attach a statement of account which clearly says that the company is not having any liability, neither the company is not having any asset. So from where that you can say legal requirement is coming is the STK 3 indemnity bond, in which we give the declaration that the company is not having any asset and liability. So whenever you, now there is one more addition to moving of the voluntary application, that the company is not having liability, you have extinguished all your liabilities, and also the company is not having any assets. Suppose your company is having cash in hand of 1 lakh rupees, you have to first dispose it off. You have to first spend it. Then after only you can move the application for voluntary strike off in STK 2. Also, you indemnify that all the lawful claims against the company, if suppose it arises in future, then the company will be, claimant will be fully liable for it. And any person, suppose if get into any losses due to this strike off, your company will be indemnifying, all the directors will be indemnifying for the same. So that is the indemnity bond which is given by the directors. So what are the attachments to STK 2? You have to attach indemnity bond. Suppose your company is a government company which is getting striked off, then you have to attach that indemnity bond in the form of STK 3A. It should be signed by the authorized representative, not below the rank of the secretary or its equivalent. So you have to assure that thing. Then after, you have to attach a statement of accounts, that is in form STK 8, which should not be older than 30 days, and it should be certified by the chartered accountant. This chartered accountant can be any, it is not mandatory to get a sign from the auditor, it can be any. Then after, you have to attach affidavit by all the directors in STK 4. If you go through the format of the STK 4 prescribed, then it asks you to affirm that you are not following any of the circumstances which we have discussed, that in which the application cannot be moved by the ROC, by the company to the ROC for the voluntary strike off. Fifth one is the copy of the special resolution or consent of 75% of the members of the company. Suppose your company has not conducted the extraordinary general meeting and passed the special resolution, you have obtained the consent, then it will be not requiring MDD 14 to be filed. Otherwise, it will be requiring MDD 14 to be filed also. You have to give the statement regarding that the company is not having any pending litigations. Also, you have to attach the bank closure letter. In addition to these 8 attachments, sometimes the ROC is also asking for the income tax returns being filed by the company. Suppose your company has not filed the income tax returns, then you have to mention it. Otherwise, whenever that notice will be issued to the income tax department from the ROC, income tax authority may object to your strike off also, or tomorrow they may go to NCLT for the revival of the company also under 252. So you have to attach your income tax returns sometimes whenever the ROC asks. That is not the legal requirement under the law, but yes, ROC is having full right to ask for it. So 248 subsection 6, moving forward, it says that now there is one more addition to the procedure being followed by the ROC before the strike off of the name of the company. It says that the registrar, before passing an order under subsection 5, it means that STK 5 shall satisfy, STK 7 shall satisfy himself that sufficient provision has been made. It means the provision has been made by the ROC for the realization of all amount due to the company and for the payment of the discharge of its liabilities. So practically, this procedure is not being followed by the ROC before striking of the name of the company. So that is one of the ground being taken by the appellants before the honorable tribunal, that this procedure has not been followed. I will discuss this case law with you later. So in that circumstances, that ROC may ask the MD, director, or any other person in charge of the management So now here they are covering three persons. One is the MD, another one is the director, or any other person in charge of the management. Suppose you are a company secretary and your management has given you the charge of management, then you may also get covered, and they may ask you to provide the undertaking also. So you have to assure that what is your role with respect to the management affairs also. Even if undertaking is obtained, then also the assets will always be available for the payment or discharge of the liability. Suppose it does not mean that you have given the undertaking, then you are completely right. Suppose tomorrow some undertaking has been given by you, and suppose the liability comes up, then your assets, suppose your company is having the asset, uh, and the ROC gets to know about it later, then your asset will be completely available for the payment or discharge of the liabilities and obligations. That is the clear-cut intention of 248 subsection 6. 248 subsection 7, it says that the liability of the company, director, manager, officer, who is having the power of management will be continuing in all sense. It is the striking of the name of the company does not mean that the liability is also getting extinguished. No, your liability will always continue. 248 subsection 8 says that tribunal is having all the power to wind up the stock of company. The question comes up that how the winding up will be done after the strike off. Then suppose your company has been striked off, later on the ROC gets to know that this company is having a property, that ROC may move the application to honorable tribunal, and proper procedure of the winding up is started under the companies that will be followed by the tribunal, and official liquidator will be appointed, and proper procedure which has been mentioned for the winding up that will be processed, that process will be followed for the winding of the struck of company. That is the intent of 248 subsection 8. Now there are certain circumstances in which voluntary strike off cannot be initiated by the company, which includes that AOC for MDT 7 up to the date of financial year. Suppose the last financial year in which the company has ceased to carry its business. So the question comes up whether this AOC 4 or MDT 7 has to be filed for all the financial years prior to moving the STK 2 application. So in my view, that you may take the contention before the ROC that AOC 4 and MDT 7 filing is required to be done up to the last financial year in which the company has ceased to do the business. Suppose the company has ceased to do the business in the year 2017, then you are legally required to file AOC for MDT 7 up to 2017. You are not required to do the filing for 2017, 18, 19, 19, 20 or further years. So in this regard, there is one, I would say, step which should be taken by the professionals, that while doing the annual filing of 2017, if your management is for sure that they are not going to do further business into that company, they should make the declaration in the AOC for MDT 7 that this is the last year in which the company is doing the business, and we will not be doing the business in the further years now, and we will be applying for the strike off after 2 years. So that can be the declaration given in the AOC for MDT 7. Then your contention, if you will take before the ROC, it will get strong, and you may not be required to file AOC for MDT 7. In my view, AOC for MDT 7 requirement is up to the last year in which the company has ceased to do the business, not further years. Suppose the company has been issued STK 1. Suppose ROC has issued STK 1 and you get to know that yes, we want to strike off this company only, and we do not want to get into trouble of that disqualification. So, and you move that STK 2, then you will be under obligation to do all the filings. So, suppose the company, your ROC has issued STK 1 to your company, then there is no recourse available. You have to move, you have to do all the filings. Then after you can go for STK 2. Suppose your STK 7 has been issued and your company has been striked off already, so you cannot move STK 2. Suppose in the last 3 months, your company's name has been changed, then you cannot move the application for strike off. Suppose your company's registered office has been shifted from one state to another. If it has happened within the city, within the state, that's fine. Suppose your company is getting the shifting or registered office done from one state to another in the last 3 months, STK 2 application cannot be moved. 6 months, suppose the application for compromise or arrangement is pending before the honorable NCLT, then also this strike off application cannot be moved. 7th one, suppose the company which has been wound up under Companies Act or IBC, then also strike off is not possible. Suppose you have moved the winding up application, but later you get to know that voluntary liquidation section 59 of IBC is not the correct recourse, and your company is not having asset, and you might have chosen STK2 application for procedure, but you are not given the proper professional guidance, you are having all right to withdraw your winding up application, which has been moved before the Honorable NCLT, and then after you can move for STK2, definitely. But suppose your company has been already wound up under Companies Act or IBC, you are not allowed to go for STK2. Eighth one is, suppose the company is engaged in any activity which is other than the activity which is required to conclude the affairs of the company. It means, suppose you have decided to strike off your company or seize your business, and you are not doing activity to which is required to seize your business, rather you are doing all other things, all other activities. Then also in the last 3 months, suppose you are doing that thing, then strike off application cannot be moved. Ninth one is, suppose you are disposing any property for the value in the last 3 months, because at the time of strike of the value of the property, you might not be able to realize the proper value, and for realizing that value, suppose you are disposing of the assets, disposing of the property or rights, then also that strike off application cannot be moved. Now, effect of strike off, I will say section 250, where a company stands dissolved under 248, it shall on and from the date mentioned in the notice under subsection 5 cease to operate as a company. So the first effect is that the company will be ceased to operate, and the certificate of incorporation issued to it shall be deemed to have been cancelled. It means the second effect is that the certificate of incorporation which was issued shall be deemed to have been cancelled from such date, except for two purposes. It means there are two purposes, still two purposes for which that company will not be considered as dissolved. That is for the realization of the amount or for the payment of the discharge of the liability. These are the two, I would say, effects for which the company will not be considered as dissolved. Otherwise, for all purpose, that company will be strictly considered as dissolved or struck off, or the name of the company has been removed. So, first effect is that the company will be ceased to operate in future. Second one will be the certificate of incorporation has been cancelled, deemed to be cancelled. Now, we have observed that list of disqualification has been issued by the ROC. Whether that is having the legal sanctity or not, I will like to comment on it by saying that it is not having the legal sanctity, because under Rule 11 of the company's appointment and qualification of director rules, the ROC is not having the power to deactivate the DIN on the basis of the company not doing the annual filing. So legally, yes, the disqualification has occurred soon after the company has failed to file the annual return for 3 financial years, containing 3 financial years. Suppose the company has failed to file the annual returns of financial statement, you are automatically disqualified. Even if the DIN is deactivated or active, that does not matter. You are already disqualified. So ROC is not having the power under Rule 11 to deactivate the DIN on this ground. So that's why a lot of writs were getting filed before high courts, and also the appellants were or the writ petitioners were having the interim relief in this regard. So that is all I would like to say about the disqualification vacation and deactivation. Now, section 251 for the fraudulent application. What is fraudulent here means, suppose if you read the application, if you read the section provision of section 251, it is only covering one. It is relating with the section 248 subsection 2, that is with respect to the voluntary application for the strike off. So suppose it is found later on that the company has moved the strike off application under STK2 for evading the liability of the company, or for deceiving the creditor, or for defrauding any of the person, then the person in charge of the management, means it not only the director, the person in charge of the management. Suppose you are the company secretary and you are in person in charge of the management, then that person will be completely liable for such loss, damage, and will be punishable under 447. Also, the registrar may recommend the prosecution to be started against that person under what is subsection 2 for doing the fraudulent, moving the fraudulent application. So, what is fraudulent here? That is the application which has been moved with the fraudulent objective. That is the object to evade the liabilities, deceiving the creditor, and or defraud or any other person. And who is liable? The person in charge of the management. What are the consequences? Punishable for fraud under 447, and registrar may also recommend the prosecution. So that is all about Fraudulent application. Example of fraudulent application. Suppose you are showing the liability nil illegally. It means you have not actually repaid the liability, but your chartered accountant is certifying that yes, all the liabilities has been paid off. So that will not be a legal thing. So that is one of the example of fraudulent application. Now touching upon section 252 subsection 1. Now if you read, it starts with the word any person. It means it is covering all the persons. It is not restricted to any particular class of person. It is allowing all the persons who are agreed by an order of the registrar. Suppose that registrar has given the order for the strike off of the name of a particular company, and that person is agreed by it. He may move an appeal to the tribunal. Tribunal here means the National Company Law Tribunal. The word used is appeal. It is not the application here. The word used is appeal because you are agreed by the order of the registrar. The time limit which has been given is 3 years, and you have to satisfy to the tribunal that the ground on which the strike off has been done by the registrar is not tenable. So you have to you cannot go for argument on the basis of the just ground under 252 subsection 1. You have to prove that the grounds, the 4 grounds on which the presumption has been taken by the ROC is not tenable, and we are completely operative in nature, or we are completely maintaining the registered office, or we have definitely paid the subscription money, whatsoever is the ground being taken by the ROC. So the time limit which has been given is 3 years. Now, before passing any order under this section, the tribunal will be giving the reasonable opportunity of being heard to the other parties also, that is the registrar and all the person concerned. So practically, which I have observed that many of the tribunals are asking the income tax authority to be made the party as a respondent. So they are giving them opportunity also to come and represent before the honorable tribunal and file their reply. So suppose second proviso says that the registrar comes to know later that the name of the company has been removed inadvertently, then he may, within 3 years, again the time limit is 3 years, he may move an application. Now he cannot be aggrieved against his own order, so he has to move an application before the tribunal seeking the restoration of the name of the company. So registrar is also having the right to move an application before the honorable tribunal under 252 subsection 1. Also, it is interesting to observe the phrase that or on the basis. In second proviso, if you read, provided that further that if the registrar is satisfied that the name of the company has been struck off from the register of companies either inadvertently or on the basis of the incorrect information furnished by the company. It means it is also covering those applications, that is STK2 being voluntarily filed by the company for the removal of the name of the company on the basis of the incorrect information. That registrar can also move an application here into 52 subsection 1 for the restoration of the name of the company. The time limit is again 3 years. So it is covering both the circumstances, that is the company has been removed by the ROC or company has been removed by the ROC on the application of company itself. So decoding 252 subsection 1, when the appeal can be filed, when someone is agreed by the order of ROC, who is having the right to file the appeal? Any person who is having the right to file the appeal. Also, ROC can file the application before the tribunal. What is the time limit to file an appeal or application? That is 3 years. When the tribunal will allow the appeal and pass restoration order, only when the tribunal opines that the strike off is not justifiable in absence of any ground, that is 4 grounds. It cannot be on the basis of the just ground. It should be on the basis of the absence of any 4 ground, any of the grounds out of those 4. To whom the reasonable opportunity of being heard will be provided? It will be provided to registrar and all the person concerned. Presently, it is provided to income tax and registrar. Now, 252 subsection. It is a little bit interesting. It says that the copy of the order passed by the tribunal shall be filed by the company with the registrar within 30 days from the date of the order. The first condition is that you have to submit your order of restoration by the tribunal with the registrar within 30 days. And on receipt of the order, the registrar shall cause the name of the company to be restored in the Registrar of Companies and shall issue a fresh certificate of incorporation. So practically that ROCs are not issuing fresh certificate of incorporation. Here the responsibility is on the registrar to issue the fresh certificate of incorporation, but we are generally not asking for the same. Also, we are not praying for the same in our appeal into 52 subsection 1, and we are ourselves admitting that we will be doing all the annual filing and all. Why ROC is not issuing fresh certificate of incorporation? Because soon it issues the fresh certificate of incorporation. Technically we will not be able to file the annual returns for the previous years. So it may be the technical glitch, or it may be the opinion of the ROC that this fresh certificate of incorporation should not be issued. But you may definitely contend the same, and you should ask for fresh certificate of incorporation. 252 subsection 3. Now we will understand the difference between 252 subsection 1 and 252 subsection 3. Now here only 4 type of persons are covered. Is that if a company, means the first one is the company, second one is the member, third one is the creditor, and the fourth one is the workman. Cannot be like any person. Now here the parties is restricted. So only the company, member, creditor, or workman, if they feel aggrieved by the company having its name struck off. Now, practically what is happening is that in 252 subsection 3, people are moving the appeal before the honorable tribunal. There is no usage of word appeal under 252 subsection 3. They are using the word that company fee, that the workman fee agreed by the company having its name struck off. It means the cases where the company has moved the voluntary application and that company was struck off by the ROC. In that case, suppose if any member, creditor, or workman is aggrieved, then he may move an application to the tribunal before the expiry of the expiry of 20 years. The time limit, the time frame given or limitation is there. Limitation of 20 years is there. So, here it is not appeal. Practically, people are moving the you can say pleading with the phrase appeal under 252 subsection 3, which is not correct. You should go for application only. Also, here the tribunal is having a little wider power to restore the name of the company, and now here the revival can be done on the 2 grounds: that the company was actually carrying on business at the time his name was struck off, or otherwise it is just, even if the company was not carrying on business, but it is just to restore the name of the company. That is means the reasonability is there that this company can be revived further or do the business further. Then this company should be restored. Only on those grounds, if the tribunal is having the opinion is satisfied, then the name of the company will be restored. Going further, it is saying that, and the tribunal may by order give such other direction and make such provision as deemed just for placing the company and all other person in the same position, as nearly as may be, as the name of the company has not been struck off. Now here the concept of the issue of the fresh certificate of incorporation is not there. They will be restoring the name of the company as if the name of the company has not been struck off. So 252 subsection 3 covers only those cases in which the company has moved the voluntary application in STK2 and the name of the company was struck off. And if suppose any member, creditor, or workman was agreed by it, they may move an application, not appeal. Time limit is 3 years, and time limit is 3 years. Sorry, 20 years, and the restoration can be done on the basis of 2 grounds. First one, that the company was carrying on business, or the company is having the just ground or the reasonableness to have its name restored to the Registrar of Companies by the ROC. What is the time limitation? Is 20 years. For the ROC, the time limit is 3 years only. Because we have read the second proviso 252 subsection 1. It says where the ROC is having the opinion that the name of the company has been struck down on the basis of the wrong information. Then the time limit is 3 years, not 20 years. What will be the effect of tribunal order of the tribunal? Then the name of the company has been restored as if the name of the company has not been struck off. The fresh certificate of incorporation will not be issued in this case. So that is the difference between 252 subsection 1 and 3. Who can file the appeal? Any person who is aggrieved. 252 subsection 3, company, member, creditor, and workman. Nomenclature is used is appeal. 252 subsection 3 is application. Limitation in case of 252 subsection 1 is 3 years. Limitation in case of 252 subsection 3 is 20 years. Limitation for ROC is 3 years always. Fresh certificate of incorporation in 252 subsection 1 it should be issued definitely, but practically it is not. 252 subsection 3, no, there is no provision for the issuance of the fresh certificate of incorporation. Where to make an appeal or application? National Company Law Tribunal. You have to make an appeal to National Company. Now, grounds for revival. So there are 4 grounds. Companies in operation, procedure has not been followed. That is, which I have discussed, that suppose STK1 was not issued, STK5 was not issued, STK7 was directly issued. That was not the procedure being followed. Suppose the provision has not been made. I will discuss certain case laws with this. Third one is the ground taken by the ROC for strike off is not justifiable. It means any other ground. Suppose the company has not paid, subscriber has not paid the subscription money into the bank account of the company. That was the ground taken by the ROC. You can challenge that thing. Suppose the subscription money has been paid, you can challenge that thing on that ground. Fourth one is the otherwise it is just. It means the justifiable grounds. I will discuss it with the certain case laws. Now, otherwise it is just. These are certain rulings in which the meaning to otherwise it is just phrase has been given. It means that the equitability, fairness, and the reasonableness. It means the Honorable NCLT has to see that yes, it is reasonably fair to restore the name of the company into the Register of Companies, and this company can go further if given one chance. So that is the test which has to be done by the Honorable NCLT before before giving any order on the basis of just ground, whether that company is having the reasonableness or fairness or not. That is the clear-cut meaning of the phrase. Otherwise, it is just. So these are certain rulings of Supreme Court and High Courts which can be used by you for arguing before the Honorable NCLT for on the basis of just ground. So moving further, suppose you want to make an appeal or application in section 252, you have to first attach the case title that will be before the National Company Law Tribunal, whatsoever is the bench, you have to give the title to it. Then after you have to attach index of appeal. It means the proper index as in case of paper book. You have to attach the index on from which page to which page is appeal, which page to which page is synopsis, and further documents. Then after you have to attach the memo of parties. In the memo of parties, there is a prescribed format for it under the NCLT rules. In the memo of parties, you have to mention the details of the parties, or you can say the appellants or the applicant or the respondents. You have to mention their name, you have to mention their address, you have to mention their contact number, you have to mention their email ID on which the registrar or the NCLT will be contacting you. Fourth one is the brief synopsis. You have to attach the brief synopsis because it is not the possibility always that the honorable judicial member will be going through whole file. So they will be going through your synopsis, and also you have to attach the list of date of events so that the relevant dates with respect to the case can be directly in eyes of honorable tribunal. Sixth one is the appeal in the prescribed format, which is NCLT 9 at present. Affidavit verifying the appeal has to be attached. Certificate of incorporation has to be attached, and MOA and AOA of the company has to be attached. Suppose your company was striked off by voluntary strike off application of yours, you have to attach STK5 and STK6. Suppose your company was striked off by the ROC action, then STK7 has to be attached. Suppose you have received STK1, then that STK1 has to be attached, and if you have filed the reply to it, and still that company has been striked out, then the reply submitted by you should be attached in that appeal. 11th one is the document substantiating the fact. This depends upon your case to case. So I won't be explaining on this particular point because it will be depending upon your case. Suppose your company is into business and you are regularly filing your GST returns. So you have to attach your GST returns. Suppose there are bank transactions, you have to attach the bank statement. Suppose your company is having have raised invoices or have entered into tenders, you have to attach those documents to prove those things. Suppose the company is having the property, you have to attach title deed for the same or the lease deed for the same. So that is the document substantiating the fact. You have to analyze on your case basis. Then after you have to attach consent affidavit for moving the application. That is not the legal requirement, but still I'm taking it from the directors and members so that tomorrow there are less chances of having the you can say misunderstanding before the management of the directors who will be in the application. 13th one is the power of attorney in favor of authorized representative. Suppose I am company secretary and you are authorizing me, so I have to take the power of attorney from you. Then after I have to attach my memorandum of appearance. So I have to attach my memorandum of appearance. In case of advocates, you have to attach your wakalatnama. 15th is the document evidencing the payment of fees. Presently, the filing fees is 1,000 rupees in case of revival of struck of companies. And 16th is the proof of service that you have served the copy to the ROC and income tax. You have to attach the proof of service to the appeal. So these are the standard documents which is required to be attached to appeal. Now 421, section 421 says that suppose you are agreed by the order of the Honorable NCLT, you may file an appeal to the NCLT, that is the Honorable Appellate Tribunal, and the time limit given to you is that the 45 days from the date on which the copy of the order is made available. Now here the word made available means, well, suppose your order was passed today and your copy has been made available online after 2 days, then that 45 days will start from those 2 days. Suppose your order has been received by you next day itself, then your 45 days will start from that day. Suppose you have failed to file the appeal within 45 days before the Honorable NCLAT, then you may definitely go request the Honorable NCLAT to extend, to condone that delay and allow you to file appeal within an additional 45 days. And if the appellate tribunal is satisfied that yes, you have failed to file the appeal due to some reasonable cause, then that appellate tribunal will be allowing you to file the appeal beyond those 45 days. But that again, that extension cannot go beyond another 45 days. So it means 45 plus 45, that is equal to 90. Also, practically you have to move condonation application along with the main appeal. That will be a separate application under Rule 11. So here of NCLT rules, you have to move the condonation application. So Honorable NCLT will be, whenever will be satisfied, then only they will be allowing you to file the appeal, or they will be allowing your appeal to be admitted. So that is 421. Now, what is the effect of struck off companies in Schedule 3? So now your financial statement should make a disclosure of your relationship with the struck off company. Suppose your company is a working company and your vendor is a struck off company and you are doing any business with them, you have to ensure that the disclosure in that regard has been given in the financial statement in Schedule 3. So you have to, there is particular categories which has been given. Suppose you have made the investment into the securities of that particular struck off company, you have to mention about it. Suppose there is certain receivable or payable, you have to mention about it. Suppose share is held by any struck off company in your company, then you have to mention about it. Or any other sort of transaction is entered by your company with that struck off company, you have to mention it in your financial. That is the new amendment, I would say. Now, important case laws. Whether CIRP can be initiated against the company which has been struck off. In case of Hemang Pupalia versus the Greater Bombay Cooperative Bank Limited and other, Honorable NCLT has New Delhi has given a very nice judgment, I would say. In that case, what has happened is that the Greater Bombay Cooperative Bank has filed an application under Section 7 of IBC against Penguin Umbrella Works Private Limited. That was before the Honorable NCLT Mumbai Bank. But corporate debtor has taken the, it means Penguin has taken the reading that the company's name has been struck off under 248. So now the question arises, question of law which arises that whether CRP can be initiated against that CD having this struck off status. So in that regard, findings of NCLT was very interesting. They have said that proviso to 248(6), it says that the company's asset will always be made available for the payment of discharge of liabilities and obligation even after the date of the order of removing the name of the company. So that was the first finding. Second one is 248 subsection 7. It says it is also clear that the liability, if any, of any director, manager or other who was in charge of the management shall continue and may be enforced as if the company has not been dissolved. It means the two purposes. One was the realization of the amount, or the second one is the paying of the liabilities. Then for that purpose, this strike off will not be considered as strike off. Company will not be considered as dissolved if it has been strike off. So definitely 248 subsection 1 also brings the liability on the shoulder of the director, manager, or any other person who is in charge of the management. Section 248 subsection 8 says that the company's name, if the 248 section 248 is in no manner going to affect the power of the tribunal to wind up the company. It means the tribunal power is still there to wind up the company. Yes, voluntary liquidation application cannot be moved by the company under section 59 of IBC, but Tribunal is having the power to wind up the company under the Companies Act. So definitely this CIRP proceeding can be initiated under 248 subsection 8. That was the intent taken by the tribunal. Intent of 248 taken by the tribunal for initiating CIRP against that company. Section 250 it says that even after removal of the name of the company from the register of companies, the company shall not be considered dissolved for two purposes. I have already discussed, that is for the realization of the amount or the liabilities or obligation of the company continues. So definitely these are the grounds on which the application for CIRP can be made against the company which is having the struck off status, and CIRP can be initiated against those companies. Also 252 subsection 3 is clearly allowing creditors to move an application under within 20 years from the date of the company's having the name struck off. So reading all these provisions in whole, it is clearly allowing Honorable NCLT has taken the view that CIRP can be initiated against the company having this struck off status, though voluntary liquidation cannot be initiated. Now, second case law, which is very relevant, is that the company was not having revenue from last 4 years, but and has also not filed annual returns, but is having fixed deposit and was receiving the interest on it. Whether that company can be revived. So, in case of Dhrorao Shriram Kelkar versus ROC Pune, Honorable NCLT has taken a very good view. In this case, what has happened is that the company was not generating any revenue or income from 2014 to 17, but company was having fixed deposit of worth 1 crore 50 lakh rupees from Bank of Maharashtra, which was also given as the bank guarantee in favor of Atal Indore City Transport Services Limited. Also, the company was regularly receiving interest on that FDR, and bank was also deducting TDS, and the same was also getting deposited before the income tax authority. So, in addition that the company has filed the reply to STK1 also. Apart from all these grounds, when the STK1 was issued to that company has filed the reply to STK1 also, and they have sought time to file the pending returns, but still the name of the company was removed from the register of companies by the ROC, and Honorable NCLT has not appreciated the fact of FDR and the receipt of interest on that. So whether question of law comes up that whether revival under 252 is is possible in these cases, then the answer is yes. In case of Honorable NCLT, finding of Honorable NCLT was that when the reply to STK1 was made by the company, ROC must have seen 248 subsection 6, which says a particular procedure to be followed, that is sufficient provision has been made for the payment or discharge of its liabilities and obligation. But the same has not been followed. It is not evident from the procedure being placed before the Honorable Tribunal by the ROC. So, first finding was that. Second one was that by the existence of the fixed deposit and the receipt of interest on it, that company, though was not having the revenue, but is making efforts to start a business by exploring the possibility. It means that company has not kept his funds idle. Its funds idle, they have invested it into somewhere, and they are receiving interest on it. So they are having the full chance to restore their name or revive their business. So their name should be restored into the register of companies. That was the finding of Honorable NCLT, and again the appeal was allowed on the just ground. Whether strike off is possible, that is quite clearly if you compare this case law with the earlier one, they are quite relatively similar. So whether strike off of the name of the company can be revival of the name of the company can be done. Suppose the company is not having the revenue, but the company is having the aggregation field of power plant. Whether the revival of that company can be done, then the answer is yes. Again, the NCLT Chennai bench has allowed the appeal on just ground. So these are certain case laws on the just ground which you can take as a reference while arguing before the Honorable NCLT or AT. Fourth one is, suppose you have some cost has been, suppose NCLT has allowed your appeal, but the cost imposed by the NCLT, Honorable NCLT, is quite high. So whether you can go for the appeal to particular part of that cost, the answer is yes. In the case of Rajinder Suresh Bhumkar versus ROC Pune, In this case, particularly what has happened is that the Honorable NCLT was satisfied that yes, the company was regularly doing the business, but still the cost imposed by the Honorable NCLT Mumbai bench was very high, that is 5 lakh rupees, and the appellants have challenged the particular cost part of that order before the Honorable NCLT. At the time of argument, the NCLT was fully satisfied that the grounds mentioned by the appellants before the Honorable NCLT clearly shows that they are having a good case to get restored, and the cost imposed by the Honorable NCLT is quite high and is not justifiable, and whole cost has been waived off, or you can say reduced, set aside by the Honorable NCLT, and there was no cost imposed on that particular case on the company. So this is all about case laws I have discussed. These all case laws can be, you can say, referred by you while arguing your case before Honorable NCLT. Isha, I am done for the presentation. So if there is any case, there is any question, I would request you to kindly take it. I would like to approach.
Thank you, Santosh Pandey, sir, for beautifully summarizing all the provisions of strike off. I request all the participants to ask questions or any queries. Please proceed.
So I'm having one question.
Yes.
There are certain questions in the question answer column. What is the difference between strike off and liquidation? If my company is satisfied with strike off condition and I opt for a strike off, and it has some effect that of liquidation or winding up. I'm not clearly able to understand the question. But suppose your company is not having any asset, or that your company is not having any liability, or your company is not having any asset, you can definitely go for a strike off. Otherwise, suppose your company is having asset and liabilities, and your company is solvent enough to, you can say, yeah, pay off your liabilities, then the voluntary liquidation procedure can be followed under section 59. Keshav, I would hope I have answered the question. So that was the first question. So the difference between strike off and voluntary liquidation is, suppose your company is not having liability, not having asset, and has not done the business from last 2 years, you can go for strike off. In case of liquidation, your company is having liabilities and your company's assets are sufficient enough to pay off that liabilities, then you can go for voluntary. That is the clear understanding. So Lubna Khan, I think there is no video and no PPT. I think the PPT and video was clearly visible. Athi Narayan, private limited company incorporated under 1956 Act, not even brought in initial subscription capital, not started business. Can it apply for a strike? Yes, definitely. Why not? They can apply for a strike off. Definitely. Can company file a strike off within 1 year of its incorporation if the company has no business? Answer is yes. Divya, I have already answered it in my presentation. You can go for voluntary strike off under STK by filing your application in STK 2, and you have to contend before the ROC. If this ROC is denying that they are not authorized to do the strike off prior to the completion of 1 year, you can argue. Definitely, you can go for it. There's no difficulty. What company, whether company, Atul Kulkarni is asking whether company can voluntarily file STK 2 within 1 year of, I have already answered. This is in relation to the question of Divya Mat. Vinay is asking companies in operative since incorporation, but having bank balance of 20 lakh, which is the paid up capital. Okay. But I think the question being asked by you is not complete, Vinay. So I think, suppose if I'm correctly able to understand your question, since it is not complete, but I am presuming it to some extent, that suppose your company is having the share capital, your company is having the bank balance of 20 lakh, your paid up capital is 20 lakh. Now the liability side is showing the capital and the asset side is showing the cash balance or bank balance of 20 lakh rupees. You have to first spend those 20 lakh rupees. You have to definitely spend those money. Then after only you can go for a strike off, otherwise not. You have to show the asset, liabilities and asset as debt. That is the clear intent of STK, clear intent of section 248. Certify by CA means it should be audited or only certified. It should be only certified. It is not. It does not require auditing. It should be only certified. AOC 4 and MDT 7. Sarita ji is asking that AOC 4 and MDT 7 is to file with NCA in case of company has filed for liquidation. To file, definitely, I think your question again is not clear, Sarita, I would request you to kindly frame your question correctly. But what I'm able to understand from the words given by you is that the company is under liquidation, but liquidation has not yet completed. Whether AOC for entity 7 filing is required, the answer is clear, yes. Yes, you have to file. You have to do all the compliance. So, Nitin Panchalji is asking, can you please share this presentation? Yes, I will share it, Nitin. No problem. Okay, thank you so much. Keshav, please take up. Keshav, I have already taken your question. RPSV and Company Chartered Accountants from Hyderabad is asking, in the statement of affairs, keep balance 0 while filing ticket 2. Yes, definitely you have to keep the balance 0 or you have to show the losses. Keshav is asking, after I have cleared all my liabilities and I have still left bank balance, can I go the leftover balance to shareholder and then close bank account and then apply for a strike off? Yes, that is the practical procedure being followed. Keshav, that is the practically this procedure is already being followed. But yes, you can go for strike after that. Okay. Now the next question from Partha Kamal Sen is that the company application can be filed with NCLT to review the cost imposed, or it should always be no, you have to appeal. There's no review for the cost. So you have to appeal before on. Whether the company is required to attach NOC from Income Tax Department while filing STK2, no legal requirement, Shamlishji. But they will be issuing notice to STK Income Tax Authority. If they will be objecting, then you might get into trouble. But there is no requirement to have the NOC from the side of Income Tax Department to be attached to STK. So that is, I think I have answered all the questions. Isha, please confirm if there is any question left to be answered. I would love to answer.
Okay,
whether in chat box also, please confirm once.
yes.
Chat box also. I have just checked the question and answer column.
I
Chat
think
box.
it is done.
I think there is one question from the side of Shivam Grover. In the chat box, it is saying that if a company has opened bank account but didn't deposit the subscription money into bank account and company has not started operations, the promoters want to apply for strike off in company time, do we require to deposit? No, I have already answered it, Shivam, that you are not required to submit the money into the bank account. Suppose me and you have incorporated a company, and tomorrow after 2 months we are not having any willingness to go further with that company, and suppose the paid capital which we have assured to put into that company was 10 lakh rupees, 5 lakh by you, 5 lakh by me, then why we will be putting that money into the company? We do not want to run it. So in case suppose NC20A issue is coming while filing the STK2 form, I have already stated that you have to file NC20A along with the clarification letter that yes, that this NC20A is being filed due to technical glitch, or to remove the technical glitch which is coming in filing of STK2. There is no requirement to submit the money. Okay, and when NCLT, Sudhiji asking when NCLT will be approached. So the time limit is 3 years in case the company name has been removed by the ROC action. The time limit is 3 years, and the nomenclature used in the pleading is appeal in section 252 subsection 1. Suppose your company has removed the name voluntarily, so the time limit is 20 years under 252 subsection 3, and the nomenclature for the pleading used is application, not appeal. Now next question is from the side of B. Shamrishji, where the company is in the process of delisting, can registrar strike off the company? In the process of delisting, then definitely not, because till the time your company is not delisted, you are a listed entity, and you cannot go for strike off till then. And can a company be strike off after 180 days of incorporation but before expiry of 1 year? Yes, definitely. That ground is clearly available in our 248 subsection 1. Suppose 180 days has elapsed and you have not submitted the subscription money, then definitely the strike off is possible. From the side of Tribunal, there is a question: what if income tax department has not issued NOC and ROC has rejected application and of a strikeout? Do company need to follow all the formalities, including audit and filing of annual returns? Unfortunately, yes, Kunal, definitely. You have to, until unless suppose you just analyze what is the actual issue on the side of income tax department. You have to analyze that thing. Practically, I have seen that some of the ROCs are asking for NOC from the income tax department, but that is not allowed. That is not a legal requirement. But if the ROC is asking for it, then you have to get it obtained. Now, otherwise there is no requirement. Where the ROC has a strike of the name of the company, can the company is required to file INC 28? ROC has strike. If the name of the company will be striked off, filing of INC 28 is not possible technically also. You have to, suppose the name has been restored. Name has been restored by the NCLT, by Honorable NCLT, and order is there in your hand. You are required to file, you are required to file that order physically with the ROC for getting it active. But the name of the company has been strike off by the ROC. Practically INC 28 will not be able to be filed. Now, next question is from Alpa Shah. If a private company with no business operations over 4 years has been struck off by the ROC suo motu, is there any additional step to be undertaken by the directors? I don't think so. If your company was not operative, definitely then your directors are not required to take any additional step. Yes, suppose your company was not doing annual filings for more than 3 years, then your directors are into trouble of disqualification under section 164. You have to ensure that your directors are not taking place as a director in any other company, apart from the companies with the non-compliance happen. Division, one of our company has not transactions during last 10 years and also failed ROC filing for last 3 years. And the director under risk for disqualification. And the fee for delay is little high. What's the remedy now to strike off? Can you file for strike off from back date? Division, no. Cannot go for a strike off from back date. Is it mandatory to file return before applying a strike off? Sumanji, I would say this question is little bit debatable. Some of the ROCs are making it mandatory for you to file all the annual returns or do all the annual filing. But as per my understanding, you have to do the annual filing only up to the year in which the company has ceased to do the business. So you can definitely take the contention before the ROC. Okay.
Any more
Okay,
questions?
so there is one more question from the side of Samrish ji. He is asking that where the company ceased its operation in 2021 and apply for strike off, and the ROC is strike off the company. However, the member applies for revival of the strike off company, and the registrar has order for revival of company. Then whether the company is required to complete the annual filing for financial year 2022 used to the operation. So when you have moved, Samrish ji, I just want to ask one counter question to it. When you have moved voluntarily application in STK2, you would have taken the consent from more than 75% of members. So in that case, practically I have not seen any case as such that the remaining members from those 25% are going to NCLT for the revival of the company. Again, suppose those members go, suppose we presume that those members are approaching NCLT for the revival of the company, then and the name of the company is getting restored, then it would be an application under 252 subsection 3, and yes, Honorable NCLT will be directing you to file all the annual returns. That is the answer to your question, Samrish ji. And now moving forward, I will be sharing my presentation within Kevin. Now Swati has asked a question which is very lengthy. We had applied for strike off under 248 subsection 2 for not bringing in capital. we had attached a clarification letter that the form is being filed only because of technical reasons. Okay. However, ROC Coimbatore has marked STK2 as invalid as per 248 subsection 2 a company inter alia by okay, in terms of this file an application to the registrar. The company has submitted that the subscribers to the memorandum have not brought in the capital. Accordingly, the company does not have any capital. In this case, the company is directed to explain how the consent of shareholders submitted can be treated as consent of shareholder who do not hold shares of the company as the company has confirmed in this reply that it has not issued shares and not opened bank account. Very good question, very good observation by ROC Coimbatore also. But where can we challenge the ROC contention by filing the resubmission, Swati? You should read subsection section 10 subsection 2, which says that the money payable by the subscriber is totally a debt. So whenever the company is getting incorporated, whenever you go for the master data, you see that suppose your company has been incorporated with 1 lakh, that master data is showing paid capital 1 lakh rupees. So soon, in the case of first subscription, you can take the contention. And in case of first subscription, the paid capital automatically becomes 1 lakh rupees, and you can show debt from members under section 10, subsection 2 as 1 lakh. Right? So tomorrow that those debt is not getting paid by the members, then that company will be considering that debt as a bad debt, and that will be a loss for the company. That is how you are going to set up your balance sheet, and you can argue before the ROC. So at the time of filing or resubmission, you can take the shed of section 10 subsection 2, but it is very, very debatable. Swati, I would suggest you to kindly have a proper research before applying for STK2 in this case with this contention. Yes, Drone Bharadwaj ji is asking that can NCLT waive off or reduce additional fees? No. Clear answer, no. They cannot reduce additional fees. After I have cleared all my liabilities and I have still left bank balance, can I go left? I have already discussed it, Keshav. You can definitely, that is the practical procedure being followed. But you have to ensure the accounting treatment given is correct. Further, if ROC, Swati has asked that further if ROC strikes off for not bringing of capital, do the directors incur disqualification? See, section 164 is not having any relation with 248. So suppose your company for which you are going for strike off, that company has failed to do the annual filing of financial statement or annual return for last 3 years. Your directors are automatically disqualified now. Whether you go for strike off, whether your DIN is active or deactive, that does not matter. You are disqualified. Your director is disqualified. That is the clear-cut provision of section 164. Now, Prem Narayan Tripathi ji is asking whether in appeal to 48 subsection 1, prayer can be made for dispensing with the requirement of completing pending annual filing for previous year if company was operative, whether in appeal under 248 subsection 1, prayer can be made. No, even if you made this prayer, they will not be admitting your prayer, sir. And 248, I'm not sure if you have quoted the correct section. What I'm presuming is that 252 subsection 1. So 252 subsection 1, if you will make this prayer, they are not allowing it. But yes, you can after the revival order is being obtained by the Honorable NCLT, you may pressurize or you can push ROC to issue the fresh certificate of incorporation. If you get successful in getting the fresh certificate of incorporation, then I would say that yes, your reducing of the additional fees can be practically seen. Otherwise not. You cannot pray for it. Can Drone Bharadwaj ji has again asked that can company file STK2 within 1 year after filing declaration of commencement of business NC20A? So if you have given the declaration for commencement of business in NC20A, but suppose you have not done the business in the first year of your incorporation, then you have to satisfy to them that though the declaration has been submitted by me for commencement of business, but I have not commenced any business. Then you can go for a strike off in STK2, otherwise not, sir. Otherwise not. After I have cleared all my liabilities, I have already discussed, Keshav, you are giving one question again. So I have already discussed your question. Whether the company is required to attest NOC of Income Tax Department in STK2, Sandhiji, we have discussed this question that Income Tax Department, some ROCs are asking for it, I have seen, but legally it is not required to be attached. I have handled certain cases wherein I have not attached NC from Income Tax Department, but the strike off has been approved by the ROC. So that is the answer to your question, sir. Anand Ayarji, thank you so much for appreciating. Vinay Kumar Pandey has asked that can struck off company sell its property? I would say that you cannot observe heartbeat in a dead person, sir. So struck off company cannot sell off its property definitely. And Alpa Shah, thank you for clarifying. And okay, thank you so much, Alpa, for appreciating. Then I would say that suppose your company is having asset and that company has been struck off by the ROC, right? So you should approach NCLT for the revival. Then after revival order, you have to do compliance of all the direction mentioned under that order. Then after you can go for selling of that property. Otherwise, it is not possible. So what I have observed is that that company was having the asset and that has been striked off by the ROC. Now professionals are giving a very, you can say, surprising advices to their client that go for the revival, get the order, make the company active. Up to the time you will do the filing, sell off the asset. Don't do the filing. They will again go making your company strike off. I would say that will be a big scam. Don't go for it. So only sell your property only after you make compliance to the complete order of the Honorable NCLT or AT whatsoever. So make sure that you are not selling of the properties of the struck off company, first of all. Secondly, even if you are reviving, then only sell the property after the compliance of the complete order of Honorable NCLT. Otherwise, it will be a difficult. Chirag ji is asking, in case bank balance is asset and share capital is liability, whether the company can repurchase of share and then strike off. I'm not able to understand your question, Chirag. But suppose your bank balance is there, you have to spend it, you have to make it completely blank, and that can be done. Suppose you have hired some professional for having the advice how to revive this company, and that professional has charged you fees, and that has brought you losses rather than reviving the company. That expense has to be shown for making that bank balance nil, or and bring your company to the losses. So that is the solution, I would say. But again, I would say I'm not an accounting person, so you should definitely have a proper accounting treatment done, right? Viral ji is asking, can you please clarify the point pertaining to requesting ROC not issue fresh certificate of incorporation in order to let the company file annual filing? So Viral, suppose you are making an appeal into 52 subsection 1 and you get an order from the Honorable NCLT for say revival of the company, revival of the name of the company, then you have to submit that order with the ROC. And under 252 subsection 2, the ROC is under obligation to issue fresh certificate of incorporation. Now, presently, they are not, any ROC is not, I have not, it is not into my knowledge that ROC has issued any fresh COI in these cases. Why they are not issuing? It might be the situation or the problem that ROC will be losing their revenue. Government will be losing their revenue because soon they issue the fresh certificate of incorporation. The requirement, technically, the filing for the previous year will not be possible. Suppose you are getting the fresh certificate of incorporation of today. Now, filing for previous years is technically not possible. So they are not issuing fresh certificate of incorporation as of today. But since it is a legal requirement on the part of the ROC to issue fresh certificate of incorporation, you should definitely contend it before the ROC. And also, though I'm not sure whether NCLT will be giving the direction on it or not, but you should make the prayer in your appeal that to appeal to Honorable NCLT and specifically ask Honorable NCLT to direct the ROC to issue fresh certificate of incorporation. So suppose that fresh certificate of incorporation in case has been issued, then that you will be able to save the cost, additional cost of AOC 4 and entity 7, which was coming on the shoulder of your company, right? So that is 252 subsection 2. Nobody has explored it. Even ROC is ignoring it. Also, professionals who are filing the appeal, they are still saying that we will be doing all the necessary annual filing. We will be doing everything. You just restore the name of the company. The direction is completely different right now. So I would say that you should push for fresh UI with the ROC. So that is what I want to explain. Am I clear, Viral? Please write it in the chat box. Yes. So okay. Thank you, Viral, for confirming. And Isha, I think all the questions has
It's
been
done.
answered.
Yeah. Thank you,
So
everybody.
these are my contact credentials. In case of any further query, I would request you to please get in touch. I would love to answer.
Thank you, Mr. Santosh, for taking up the doubts of the participants and for your valuable time and sharing with us all the information. Now, I would like to conclude by sharing some points from the webinar itself. Firstly, strike-off can be done only on specific grounds. Even voluntary strike-off can be done on specific grounds. Company, if wants to apply for strike-off, first of all, it's required to extinguish all its liabilities, then can apply either bypassing SR or a consent of 75% members. Then can apply for strike-off. Sir beautifully analyzes the provisions of section 252 subsection 1 and 252 subsection 3. Section 252 subsection 1 states any person can appeal against the order of ROC to NCLT within a period of 3 years. And section 252 subsection 3 states company or any member or creditor or workman can file an application to NCLT against the order of ROC within a period of 20 years. So it is not an appeal, it is an application and it is given by 4 persons. As whereas section 251 subsection 1 states any aggrieved person, it can be given by any person. And the period is within a 3 years. ROC can also appeal to NCLT within a period of 3 years, where ROC has a reasonable ground to believe that the company has company is going on with a business. Then ROC can also file an appeal.
Just one thing I want to add here, that even in 252 subsection 3 or practically in 252 subsection 1 and 3 cases, what I have seen that people are making the company party as a appellant or the petitioner or the applicant. So company has already been struck off. So how the struck off company can be a party? That is the biggest question. So whenever you are moving an application, just move on the basis of the on behalf of the member or the director, not on behalf of the company, because company cannot pass the board resolution. Company cannot give you power of attorney, which has been struck off. So in 252 subsection 3, I would say there is a drafting error. Only member, creditor, and the workman is allowed to file the application. And in 252 subsection 1, also any person apart from the company which has been struck off. So be assured with that.
Yes. And the effect of the struck off companies is also required to be shown in the schedule 3rd, that is the financial statements. And any aggrieved order, any person aggrieved by the order of NCLT can also appeal to appellate tribunal. And lastly, I would conclude again by saying thank you, Mr. Santosh Pandey, for your patience, for your valuable time, and for sharing with all of us so useful information.
Thank you so much, Isha, Subita ma'am, and whole Taxmann team. And thank you all the participants to be participative. Thank you so much. Thank you so much.
Thank you, sir.
Thank you. Signing off.
Thank you, everyone.